All right, next we have Young, BOCK, SHIM, and CELLUMED versus Frederick, is it Buchel et al. And we have kind of an unusual question to ask before everybody gets started. This is a case in which if there really were paper files anymore, there would be boxes and boxes. We have a reply brief filed in response to Biomedical's answer brief. Apparently, the reply brief intended to be filed in response to the merits of the bigger case. Both reply briefs apparently were rejected. The doc stamps brief against the Biomedical Trust got refiled. The other one on the merits did not. Did y'all receive the reply brief on the merits to the major part of the case?
We did.
Okay. All right. So there was so many things here. It's floating around, and I think your office has been contacted now this morning to refile that brief. So since they have received it, we can consider it, but without knowing that answer, I wanted to make sure that we had everybody on the same playing field. So if I take a deep breath, we'll be fine, and we'll go forward, and just let us know if you need something other than 5 minutes for rebuttal.
Good morning. I'm John Bogdanoff for the appellants, and I will reserve 5 minutes for the rebuttal. And I'd also just like to wish the panel and all in attendance happy Constitution Day today. There were several errors that we raised in the briefs in connection with the entry of the final judgments for the appellees, the most consequential of which involved the direction of a verdict for the appellees, not only on appellants' claims for damages, which were based on fraud and misrepresentation and deceptive and unfair trade practices, but also on appellants' affirmative defenses to the appellees' counterclaim. The court, in directing a verdict, we believe, misapplied Florida law, particularly the Billington case, regarding the appellees' attempted use of a due diligence clause to avoid liability for fraud and misrepresentation. We also believe that the court misapprehended the evidence, failed to consider it in the light most favorable to the appellants, the non-movants. The evidence demonstrated much more than simply a failure to disclose material information, which it did, but it also included evidence of affirmative misrepresentations by the appellees. It included active concealment of material facts, and it also included evidence of a scheme to deceive. As the panel is aware, the stock purchase agreement included at paragraph 6 a due diligence clause, 2 sentences. Okay, it was inserted by the appellees 3 days before the agreement was to be executed.
Why does the timing of that, why does that matter?
Well, it's important because the totality of the circumstances here reflect a scheme to deceive. We believe there's ample evidence of that. Not only was it only inserted 3 days before it was to be executed, the appellants did not even have all the documents they would have needed in order to conduct a due diligence.
But I hear what you're saying, but isn't that the time that your client steps back and says, hey, we're not okay with this provision, we only have 3 days to conduct this due diligence?
A couple of points. One is, before they were sent the copy of this proposed agreement, they were required to put $2 million, make a $2 million down payment. So they already have $2 million being held by the appellees. Number two,
Are you saying
they don't have all the
forfeit
documents.
the $2 million if they didn't close within those 3 days?
Well, it's not clear whether they could have requested an extension or whether an extension would have been granted. But the fact of the matter is this was inserted 3 days before the agreement was to be executed. And the appellees knew that the documents, appellants didn't even have all the documents they would have needed to conduct a due diligence. So there's really some question here as to the reason why it was inserted at the time it was.
Well, there was there's quite a bit of information in the public record, correct, on these issues, including the federal case.
The federal FDA case from 2006 did not include this BP mobile knee. So, in fact, the appellants were informed that that litigation did not involve this knee. So, whether or not due diligence could be conducted in 3 days.
When you see a case like that involves a whole lot of products and a whole lot of similar issues, does that not raise a red flag that perhaps we need to take a closer look at things?
Well, I think you can also look at it from this standpoint. The appellees told our client that it did not include the BP mobile knee. That was not included. So I think given that representation, our client is satisfied that, okay, this litigation does not include the knee, and there's no reason to be concerned. Had there not been that representation.
Hypothetically, what if there's 10 products and 9 of them are subject to the federal litigation, and your client only cares about the one that currently is not? If 90% of the products are subject to challenge, does that by itself not raise a serious question mark concerning the one product that is not yet part of the litigation?
I think given the affirmative representation that it was not included, then I think that does give our client some solace that he's been assured that this is not a product. I mean, we're talking about world-famous orthopedic physicians. These doctors are well-known around the world for designing and producing these orthopedic devices. So I think when you take that plus the fact that...
The only people who can mislead you are people that you trust.
Well, but the law also...
That's how it works. It's got to be a reasonable reliance. So, I mean, that's not that unusual that the people who are making the misrepresentation, if it was one, and apparently it was, that you're supposed to get your own information and have your own experts look into it. And if the BP mobile knee being approved by the FDA was really the core of the deal, it should have been in there about paragraph 1 or 2. It has been approved.
Right, but the doctors did tell our client that it had been approved. They affirmatively said it had been approved. And I would agree that there's a lot of circumstances surrounding this issue of reliance.
Didn't they say the other products had been approved as well? Wasn't that sort of what was going on in the federal case?
No, the federal case involved different products, and there was
well, I know it involved different products.
Well, the FDA had challenged those products, and really
exactly. That's kind of my point.
Right, but I don't believe...
Wasn't there a pattern of behavior that was sort of, that would be demonstrated by a look at the federal case?
I don't believe so, but if there was, all of that would have been relevant for a jury to consider. You know, the whole concept of reliance here, that was an issue for the jury. Was it reasonable not to ask for an extension when you get this 3 days before you're supposed to execute? Was it reasonable to include it 3 days before? Was it reasonable to ask for $2 million before we send you this contract that includes...
Is it our job to go back and say this is a good contract or not because it's not fair? It's a do-over?
No, it's not. But in this case, the situation is this. The appellees are trying to rely on that due diligence clause to absolve themselves as a matter of law from liability for the fraud claims. And they did so the trial court did so based on the Billington case. The Billington case does not provide a substantiation for that contention. As Judge Harris, I believe you were on the Billington case as an associate judge. The Billington case involved express disclaimers of liability. Conspicuous, they were in caps.
And a waiver provision as well.
Right, and an express waiver of liability for any claims. That is not our case. Furthermore, Billington talked about the requirements if you're going to try to absolve yourself of liability for fraud or misrepresentation. It needs to be clear, conspicuous, and comprehensive. There again, we don't have a situation where we have a clear, conspicuous, and comprehensive waiver or disclaimer.
Well, I mean, that's a conclusory statement. What isn't clear and conspicuous about the provision here?
Well, if you look at Billington and then you look at a recent case we cited as supplemental authority, Rodriguez, in those cases, the disclaimer language was included in caps. In other words, the reader is going to see that and realize, uh-oh, this is important. In this
These
case,
are sophisticated parties, right?
well, in this case, three days before the contract is to be executed, paragraph 6 is inserted. There's nothing conspicuous about paragraph 6.
Well, your client knew about it, right? Your client didn't just miss it.
Well, I think the bottom line is the client in 3 days cannot do,
And so I'll go back to my first question. Isn't between two parties, that are negotiating a contract at arm's length, when one party attempts to insert an objectionable provision into the contract, isn't it the other party's right, obligation, duty to say, no, I'm not okay with that?
I think that would be an issue for a jury to decide whether or not the party acted.
Before the contract is formed?
Well, I think in this case.
So now juries are gonna sort of referee the formation of the contract?
No, they're going to decide whether or not reliance on a provision is reasonable or not. Typically, whether or not a party acted reasonably in reliance on a
But they're going to look at the way the contract was formed between, I mean, you would agree these are sophisticated parties, correct?
Well, I would agree that the doctors are sophisticated parties. Our client is a Korean national. I don't know that he is, I can't say that he's a sophisticated buyer in the sense that he has the equal, equal knowledge and as to the ways contracts are formed in the United States. But I don't know that that really, is pertinent to the issue that the trial judge considered, which was Billington forecloses this. We're not even going to let these facts go to a jury. We're not going to let the jury consider the totality of the circumstances. The judge blocked this case and the affirmative defenses of fraud and misrepresentation on the appellee's claims from going to the jury on the basis of reliance on Billington. And Billington simply does not apply. The other important factor about Billington is that even in Billington, where we had comprehensive, clear provisions of disclaimer and waiver, the court certified the question to the Florida Supreme Court as to whether a party can, under any circumstances, disclaim or waive a liability by contract for fraud, noting that the Florida Supreme Court opinions from some 75 years earlier were kind of confusing on that issue. So even the Billington court...
Kind of.
Yes, they were confusing, no doubt. And the court certified the question. Unfortunately, it appears that the parties reached a settlement or accommodation, and that issue, those questions were never actually brought to the attention of the Florida Supreme Court, so we never got an answer. But at the very least, even if Billington applied to this case, which it doesn't because we don't have clear, comprehensive provisions of disclaimers or waiver, but even if it did, there's a real question that the Florida Supreme Court has already been asked to answer as to whether a party can disclaim responsibility for fraud by way of a contractual provision. So for all those reasons, this,
Counsel, I'm looking at the provision now. What is unclear about this provision?
Well, it talks about the buyer will rely on the information furnished by its own experts or individuals rather than on its own information, on the information furnished by the seller. Does information mean representations, or does it just mean information, documentary information? It doesn't say may not rely on representations that were made. And if a party's going to attempt to avoid liability for fraud...
Is a representation not information? And what, I mean, help me get my head around that.
Well, I think if a party's going to try to avoid responsibility for fraud, the party's duties, as Billington says, are to be clear, conspicuous, and comprehensive. There's nothing clear, conspicuous, and comprehensive about that provision. What does information mean? Does information mean anything, absolutely anything, or does it mean...
Any information. I mean, what definition of information are you using here?
Well, there is no definition of it. There's no definition
Well, give me the
there.
dictionary definition you're using, because I guess I'm having a hard time getting my head around your understanding of the term information.
My definition of the term of information is that where a party is required to expressly, specifically disclaim liability for fraud, use of the word information does not satisfy that requirement when it comes to affirmative misrepresentations that have been made. If a party wants to disclaim responsibility for affirmative misrepresentations that they've made, then they can do that. And in fact, the TRG Nighthawk and the Mac Gray case both say they can do that, but they have to do it specifically. They have to be explicit. And this does not qualify under that.
Let me ask you, do you want to talk about something other than the Billington issues before your rebuttal time comes up?
Yes, we did raise several different additional points. One is there was evidence in the record. The judge also granted the directed verdict on the basis that he didn't think there was evidence of damages. There was testimony that as a result of the FDA cease and desist order in 2011, our client had to scuttle $500,000 in BP mobile knees, which were no longer usable. But we think at the very least...
Right, that was clear evidence. You also argued in the brief that the difference between the sales price and the book value on the day of the sale was whatever it was, a couple of $1 million or $1.5 million, whatever the number was. And you said that should be the measure of damages. Isn't a party entitled to sell its business for more than it's worth if the seller's happy to pay for it?
Yes, but I think...
So how is that then a measure of damages for a breach of contract?
I think that's a point that could have been argued to the jury, whether or not they paid higher than the book value or whether or not the book value was due to the fact that they didn't get what they bargained for when they purchased the business. There again, another question that the jury should have been allowed to answer.
All right, and on the damage issue for the unpaid royalties, do you want to touch on that briefly?
There was testimony, expert testimony from Dr. Crane, approximately 1.6 million. The remainder, the 1.4 million, was all speculative. It was based on a Australian customer who hadn't done business with this Endotech since 2011.
Wasn't part of the problem because your clients weren't providing the monthly or quarterly reports on their sales? Didn't that make it difficult for BP to go for it?
That's what the appellee argued on appeal. But there was no motion to compel. And had there been a motion to compel and those documents had not been provided, the trial judge could have appropriately given an instruction to the jury that, these documents have not been provided. You may then, use your best knowledge. You may then, use whatever other evidence there is in the record. In other words, the jury isn't just left on it to use its own devices to pull numbers out of the air. The jury is given an instruction. If there's no substantial competent evidence, then an instruction could be a substitute for that. But that didn't happen here. There was just pull some numbers, speculate, see if this guy from Australia he didn't even know about the 2011 cease and desist order. Just take some numbers that you can find wherever you find them and see what you can do. So there was a mechanism, but that mechanism wasn't utilized here. I'd like to reserve the remainder. Thank you.
One attorney arguing for all the appellees?
Ed Kester for all of the appellees, accompanied by my co-counsel Seth Horace, and I will be arguing for all of the appellees.
All right, great.
Information by the Oxford Dictionary is defined as facts provided or learned about something or someone, what is conveyed or represented by a particular arrangement or sequence of things. I heard...
That include misrepresentations, affirmative misrepresentations? Is that information?
Absolutely. And I would point out that Billington sets forth that the court ought to strike a balance in order to give people certainty in their contracts and to avoid the fabrication of fraud to have cases go forward.
How does your non-reliance clause in this case stack up with the one in Billington?
I think our non-reliance clause is actually superior because it says not only are they going to not rely on us, it says that they're going to hire their own experts and they're going to agree on their own experts, and then they rep and warrant
What
under...
are their experts supposed to do in 3 days?
I heard the 3-day argument, which I find perplexing, and the reason I find it perplexing is there is no dispute that Mr. Shim was doing business with Dr. Beekle and Dr. Pappas through Endotech prior, had a prior license agreement, and approached them to buy their company. The original stock purchase agreement, which appellants in their brief say only provided slight mention to the FDA litigation, is dated January 26th, 2009, and rather than a slight indication about the FDA litigation, it gives quite a robust description of the FDA litigation, and they even negotiated.
Disclaimer or your non-reliance language put in 3 days before they had to sign it? Yes or no?
They had no obligation to sign it.
I'm asking about the 3 days. That's not some made-up time frame.
For
That clause was inserted into the proposed contract 3 days before the signature was due?
For purposes of the appellate argument and the directed verdict standard that we're looking at de novo, I will agree it was provided 3 days, but only for purposes of assuming, for purposes of being here, because we're on a de novo standard of review. My point is, the first agreement...
Counsel, the point is their option was sign it do whatever due diligence they could within 3 days and sign, or walk away, right? I mean, theoretically, those were the two options.
Well, there's even a third option that actually occurred. They entered the first agreement. The first agreement they entered on a particular day. It discloses the FDA litigation. It has the non-reliance provision. And they renegotiated to remove the Uniform Commercial Code section. And they entered into yet another stock agreement on a different day, January 30th of 2009. So I hear appellate's counsel tell you there was a scheme afoot to force them to sign the first agreement, and they had to close immediately, yet the actual undisputed record is they actually renegotiated after the first agreement, made it better for themselves to not have to have a UCC1, and then liquidated all of the business assets after the sale and never paid on the promissory note, and actually breached the promissory note and the payment of royalties prior to ever receiving the FDA letter. So for appellants to contend that there was some sort of contract of adhesion against a sophisticated party forcing the party to enter into an agreement is directly inconsistent with the actual undisputed facts before this court, which is it was renegotiated after provisions were actually changed and it was actually signed and finalized on a different day. With respect to Billington, Billington tells us we have to strike a balance between allowing sophisticated parties to enter into contracts that would avoid the fabrication of fraud and allow for certainty. So when the question is a false representation or information, the first issue is, can you fabricate a fraud claim directly inconsistent with your contractual arrangement so that you can take anything to a jury in Florida? The case law tells us absolutely not. Billington is very clear, and the TRG Nighthawk is very clear. You cannot do it.
Well, counsel, wouldn't your provision here have been a little more clear, I guess, if it had said not just information, but, including fraudulent representations? Wouldn't that have sort of made it really crystal clear to the other side that, hey, look, we can lie to you. We can tell you anything we want to tell you. You can't rely on that.
It would not have hurt to say we could make fraudulent misrepresentations. To take it a step back, what we're actually talking about is not even a fraudulent misrepresentation. If you take the appellants at their word, the appellants contend that Dr. Pappas told them that he believed going from a slot or one hole to a slot did not make the device mobile and did not change the classification. They also admit they signed an agreement that disclosed the FDA litigation. The FDA litigation on its face said Dr. Pappas and Dr. Beekle are serial abusers of the FDA rules, and the FDA disagrees with their interpretation. They get actual notice of the lawsuit in detail. They get notice that they
notice from?
What's that?
Who did they get the notice from?
They got the notice in a signed agreement.
From your clients?
From my clients.
This contract says don't rely on anything we tell you,
Correct.
but they're supposed to rely on that.
for purposes of addressing non-reliance, non-reasonable reliance, they're told they can't rely on us. They're told about the existence of the federal lawsuit in some detail.
Your point is that you disclosed the lawsuit, which
Correct.
had the information.
Well, the lawsuit had, the importance of disclosing the lawsuit is when you read the lawsuit, you can't possibly say, my clients are experts at FDA rules and the FDA agreeing with my clients. My clients are one of the few people that the FDA have sued and that my clients took up to the 11th Circuit. Now, it's true that the agreement says they will not rely on any information that we provide, but that doesn't mean that they can take the opposite position of the information we provide. So if we tell them the FDA is suing us and the FDA disagrees with us, and here's the FDA's lawsuit and it's public record on Pacer, and your company's being purchased by a very sophisticated person, they can't come into court and tell a jury and a judge, hey, wait a minute, even though I knew about the FDA litigation, even though I signed an agreement, even though I said I would hire my own experts and rely on my own experts, I reasonably relied on my belief that they must have been right and that they were experts in FDA rules, and their opinion is something that I relied upon.
The difference between conducting due diligence and relying on a representation.
Correct, and their position is actually directly inconsistent with the contractual language and the disclosure of the FDA litigation.
Was the knee particularly listed or identified in that FDA litigation?
Pages 13 through 15 of our brief, we document that, in fact, it was specifically listed and addressed in the FDA litigation. And ironically, we also list that Hollis Rhodes was one of the people that the FDA listed as having knowledge. And when we took
Did
Hollis...
Hollis then say, though, that one of the fellows said that, well, we talked to them about that and they're no longer pursuing the knee in that litigation, or am I mixing something up here?
You're not. You're simplifying it in the sense that Dr. Pappas was deposed in the FDA litigation. And Dr. Pappas in the FDA litigation simply said, in more eloquent engineering terms than I'm competent to provide to the court, that going from the hole to the slot did not convert it to a mobile device and did not make it a Class 3 device, and therefore you guys should drop this part of the lawsuit, not go to trial on it, because I'm only protecting people. Because if I took the pin out entirely, it would be mobile, and if I just give it a little bit of wiggle room, it allows for the pin to stop rotation and just makes it a more robust device. And from engineering terms, even a singular hole still allows articulation or movement. The FDA, after his deposition and after receiving the interrogatory responses and request for admission responses, did not try the case on this issue. They did do audits of Endotech. They knew Endotech was selling these things. They knew all about it. They definitely had it in their complaint, and they definitely had it in their discovery, and they definitely deposed Dr. Pappas on it. One of our core points is Dr. Pappas's personal belief that going from the pin to the slot does not change the classification is precisely why the agreement says you can't rely on him. You have to get your own experts. They could have hired Hollis Rhodes. One of the first questions I asked her on cross-examination was, were you available to be retained at the time the purchase occurred? And she was available to be retained. He was supposed to hire his own experts. Another important fallback, undisputed in the record, is Mr. SHIM, prior to even entering into negotiations to buy the business, had already had a copy of the official 510K file for the device I'm holding in my hand. I have the rest of the knee there with the hole, used it to get South Korean FDA approval, and was selling with South Korean approval by their FDA in South Korea. So he didn't come to this contract as a stranger. He didn't come to this contract with no opportunity for due diligence. This is a person that had already been selling the product. And they allege in their brief that one of the reasons they bought the business is because our guy was doing it as a hobby, and they wanted to be able to manufacture and sell more of these knees in South Korea. So that is a very, very key thing here. And there isn't anything in Billington that would say by misalleging or by trying to exaggerate your fabricated fraud claim, you somehow can get around the non-reliance. But the undisputed evidence is they knew.
The non-reliance clause, which includes the term information, that also is broad enough to encompass opinions
Absolutely. And the reason it's broad enough to encompass opinions is information, as I read to you, is more than adequate in terms of a definition that would cover opinions. And second, fraudulent misrepresentation can't be based on opinion anyway. It has to be based on fact. So the fact is, undisputed in the record, they had the actual 510K approval well more than a year before they entered into the transaction, used it for their own business purposes to sell knees in South Korea. And then they come back and say, well, we thought, Dr. Pappas was famous and we wanted to rely on his opinion and then not do our own due diligence. It was still an opinion. So even if there was a
I want to get back to comparing the non-reliance clause in your case with what we found in Billington to be clear, conspicuous, and comprehensive, where it includes in all caps all current prior understandings, statements, representations, agreements, oral, written, including representations contained in brochures, advertising, sales materials. It goes on and on and on. And then it says, buyer acknowledges, being the plaintiff in that case, he has not relied on such items. You don't have any of that in this case, right? We don't have it. We just use the word information.
I have better due diligence examination of business.
I'm not sure that's better.
The buyer has employed or will employ before closing such experts or individuals as it may deem appropriate to fully examine the affairs and the business of the corporation. The buyer will rely on the information furnished by these experts or individuals rather than on the information furnished by the seller in the buyer's decision to purchase. So we have, I agree, anything you told me, I'm not going to rely on. I'm going to hire my own people and rely on them.
You told me it's information you've provided, and I think there is some ambiguity whether that includes representation, certainly misrepresentation. I don't think it's as clear as you're saying. Information is not representation. In Billington, they said what exactly was included. Here, just the fact that we're debating what information means, doesn't that mean it's not clear, conspicuous, and comprehensive?
Absolutely not, and the reason is you go then add paragraph 9, truth of warranties and representations. The warranties and representations of seller and buyer shall be true as of the date of the agreement and shall continue to be true until closing. That includes their representation. They're going to hire their own experts. And then if I go to paragraph 17, we have all prior understandings and agreements between the parties are merged into this agreement, which alone fully and completely express their understanding. So I would purport that even if we go all the way back to the Kasich case, the 1939 Florida Supreme Court case, and I grant the confusion between the Kasich case and the Oceanic case and then the later Billings case, you had a sophisticated hotel purchaser in the Kasich case who the Supreme Court said in their particular case, a merger provision was sufficient. Here we have a non-reliance, a representation and warranty section. There's no rep or warranty related to 510K classifications or Class 3. And then we have a merger provision to top it all off under 17. And then you have the actual disclosure of the FDA litigation where the FDA actually in the lawsuit says that they think that this knee is mobile and they think it's Class 3. So you have actual knowledge of the FDA disagreeing. You have, I agree not to rely on you. I have a merger provision, and I have a rep and warranty provision. And under those circumstances, there can be no reasonable reliance, and we clearly fall with under TJR Nighthawk. We clearly fall
ask you,
under.
if I can, one more question about Billington, and then I'll move on. But in Billington, we say an express waiver of the right to maintain a fraud claim is all that's required to avoid liability for fraud. There is no express waiver of the right to maintain a fraud claim in your case, correct?
I disagree because information covers all representations.
Not express.
It's
If you're
express.
waiving the right to sue for fraud, you put it in there, and then there's no debate.
Any fraudulent representation, negligent misrepresentation, or true representation still falls under the envelope of information. So
Right.
the
In
idea
Billington-
is to be broad.
In Billington, they say, we waive any claim. Yours doesn't have that language in it, does it? That we waive the right, we waive any right or claims arising from any such statements, promises, or representations. I mean, that goes beyond just a non-reliance, does it, in Billington?
This says the same thing. It's a distinction without a difference. The buyer will rely on the information furnished by these experts or individuals rather than on the information furnished by the seller. And then under 9, they represent that that's true. So they have contractually put themselves in the exact same spot. They have unequivocally agreed
Counsel,
they
what
would not.
claim does the appellant have if this provision eliminates reliance?
They have no claim whatsoever.
Is reliance a necessary element of the claim?
Absolutely. You cannot sue for fraud without reasonable reliance.
How about in FDUPTA? Do you have to prove reliance in that?
Under FDUPTA, if you have contractually agreed not to accept a representation and rely upon the representation, then you cannot base a FDUPTA claim on it. And that's the TGR
So in
Nighthawk.
short, your position is reliance is necessary as well? for
Unequivocally. And then for the entire fraud concept, you have to choose the out-of-pocket or the benefit of the bargain damages, and you have to prove the value of the stock on the day you bought it under all circumstances, and that's the Merrill Lynch case. You can't come in with tax returns and other things and argue about book value. They absolutely had to come in with an expert and say, this is how much it was worth on the day I bought it if the representations were true, and here's how much it was worth if the representations were false. And then they have to choose whether, under the flexibility theory, one of those two options. There is no option for saying, I just would have made more money if this was true, and there is no option for taking the tax returns out and trying to compare book value. Book value has nothing to do with market value or the flexibility theory of damages available for fraud under Florida
So
law.
doesn't this case really come down to the non-reliance provision? I mean, if the non-reliance provision wasn't in the contract, this would be a reversal. Do you agree with that?
I don't, and the only reason I don't is if the court had articulated a directed verdict solely based on the fact that the FDA litigation was unequivocally disclosed, that it was a matter of public record as well, and unequivocally listed this knee, and they had actually signed a document saying that they had been disclosed
Doesn't that become a fact question then? I mean, if it's...
All reliance issues don't become a fact question if they're unequivocal on their face. And under those set of circumstances, they would still be unequivocal on their face. No different than, for example, if you had somebody agree to buy a car for $10,000, and then later on, they sued and said they thought they were only paying $8,000, and the court was looking at the difference between the contract where they all agreed they were going to pay the $10,000, and they were looking at a plaintiff saying I was fraudulently
The
induced.
fact that the FDA didn't pursue this product, though, in the litigation, wouldn't that be enough to make it equivocal? Wouldn't that be enough to send it to the jury?
No, because you still have the issue of it's an opinion, not a fact, so it can't form the basis of a negligent misrepresentation, fraudulent, or a FDUPTA claim in any event, and then you have the fact that it was disclosed. And you have the sophisticated purchaser, which they had, for example, in the Casa case back at the Supreme Court. Then as it relates to the promissory note, if I could bring the promissory note issue up real quick. First of all, undisputed that Mr. SHIM is a South Korean resident, South Korean citizen. That's even his address on the final judgments. No taxes in terms of documentary stamp tax would be due for that simple reason. We also have the issue of the statute was in fact changed. And so we see the other side rely on the SOMA case, and the SOMA case doesn't fit our factual profile for two distinct reasons. The first reason is the statute was changed, it was applying an old statute, and the second reason is SOMA says they should have abated the case so the taxes could be paid, which the court did under SOMA anyway, just in case SOMA applied, and they were paid on the internet during a trial and given to the court. We see in the other side's brief that the new statutory change shouldn't affect SOMA, and SOMA should still be considered to be the law of this court, and they say under 2.01081B, what else could the court mean, or what else could the statute mean when it says you can't enforce particular instruments or other instruments? And if we go to that specific section, it's interesting because 20108(1)B at the end, the part they rely on in their brief, says other instruments, it says refers other evidence of indebtedness filed or recorded in this state. They say, what else could that mean but to invalidate promissory notes? Promissory notes aren't filed in this state with the clerk of court. So when you look at everything under 1B, when you're talking about mortgages, you're talking about deeds of trust, you're talking about other instruments and evidence, debt, indebtedness, or collateral that are recorded at the clerk of courts.
I'll go ahead and wrap up your times.
I will.
Expired.
Anyway, in any event, I just want to make the point that the new statute is very clear. It doesn't apply, and I want to hit real quick the argument that they make that that stock is personal property, and therefore anytime somebody gets a promissory note to buy stock, they would have to pay documentary stamp tax or not be able to enforce it because stock is used. If I own stock in IBM, looks like I'm out of time.
You're beyond out of time. So we'll let you run a minute over as well.
Thank you.
Counsel, what claims remained, assuming this court determines that this provision eliminates reliance, what claims do you still have? What claims remain if there is no reliance?
Well, we do have the FDUPTA claim because, contrary to what you heard from the appellees, we cited the Davis versus PowerTel case, which says that under those deceptive and unfair trade practices claims, it's not actual reliance that's necessary. What is required is that the actions were likely to deceive, is the words that the PowerTel court. So they reject any contention that it's actual reliance. So definitely have that FDUPTA claim, even if the court were to address or conclude that there was no reliance. But we don't even think that is correct for several reasons. You heard opposing counsel say, oh, Dr. Pappas made a statement of opinion. Well, first of all, Dr. Pappas said that this BP mobile knee was approved by the FDA. Okay, he didn't say, in my opinion, it was he said it was approved. He told Mr. SHIM, according to Mr. SHIM's testimony, that it was approved by the FDA. Secondly, and we cited a case in supplemental authority, and it's in our reply brief, statements made of opinion by somebody with superior knowledge can be deemed to be fact. That's an issue for a trier of fact. There's no doubt here that Dr. Pappas, who designed the BP mobile knee, and in fact put several memorandum to file into the file which were not available to the FDA, in which he indicated in a somewhat deceptive way that he was that this was not being approved by the FDA. Was not even going to be submitted to the FDA because they were afraid it wouldn't be approved, but there's no doubt that he is in a position of superior knowledge. This man designed the BP mobile knee. So there is ample case law saying that that's not a statement of opinion, that is a statement of fact. A jury could easily find that.
Counsel, another issue that I think seems important that I'm still sort of trying to get my head around is the interpretation of information. And so I guess my question here is, what is the point of having a non-reliance provision in a contract if the term information only means accurate information?
Well, it would have been so easy to just put in there, no representations may be relied upon. The burden is on the party.
I'm going back to your definition of information. If information only means accurate information, then what is the point of this provision? What's the effect of it?
Well, first of all, it doesn't say accurate information, it says information.
But isn't that your definition of information?
The definition, I don't know the definition because I didn't prepare this clause. They prepared it. And it was their burden, if they want to avoid as a matter of law, liability for fraud, they know how to do that. There's case law. There is no case law that they've cited to you.
But doesn't that beg the question? So they use the term information, and your position is that the term information is not good enough, right?
Correct. It doesn't go anywhere near
Isn't
necessary.
your definition of information accurate information? The information provided has to be accurate for it to qualify as information.
No. Our position is that if they want to disclaim liability for fraud as a matter of law, they need to be specific. They need, and that's what the...
But that begs the question again, why is the term information not specific?
Because it doesn't encompass representations. For instance, opposing counsel read paragraph 9 of the stock purchase agreement. The warranties and representations of the seller and the buyer shall be true as of the date of this agreement and shall continue to be true until closing. Well, does that mean the representations that Dr. Pappas made? I mean, Dr. Pappas made a number of representations. And in the stock purchase agreement at paragraph 9, it says, those representations shall be true as the date of closing. So at the very least, what we have here is an ineffective effort to disclaim liability for fraud. There's no case holding that the language that they used in and of itself is sufficient to disclaim liability for fraud. The Billington case tells you if you want to disclaim, here's how you can do it. We're not even sure you can because we have to ask the Florida Supreme Court if we're right about that you can under those circumstances, but certainly you need to be clear, you need to be conspicuous, and you need to be comprehensive. This provision at paragraph 6 doesn't satisfy any of those
All right,
requirements.
and you're out of your extra time as well. Thank you. The case was well briefed and well argued. There'll be another proceeding starting at 10:30.